The hearing to confirm Judge Coney Barrett to the Supreme Court will now begin. I appreciate everyone's cooperation, and we will have a hearing, hopefully, that the country will learn more about Judge Barrett, learn more about the law, learn about the differences in judging and maybe the differences in the party. If that happens, it'll be a successful hearing. As to the hearing room, I doubt if there's any room in the country that's been given more attention and detail to make sure it's CDC compliant. The architect of the Capitol, working with the attending physician, has set up the room in a fashion that we can safely do our business. Senator Lee is back. You've been cleared by your physician. Welcome back. The COVID problem in America is real, it's serious, it's dangerous, and we have to mitigate the risk. I would just let every American know that many of you are going to work today, probably already been at work, and I hope your employer will take care of your health care needs. But we do have a country that needs to move forward safely, and there are millions of Americans, cops, waitresses, nurses, you name it, going to work today to do their job, and we're going to work in the Senate to do our job, and one of the most important jobs the Senate Judiciary Committee will ever do is have hearings and confirm a justice to the Supreme Court. So for housekeeping purposes, the first day has traditionally been opening statements by my colleagues. We'll do 10-minute rounds, and everybody will have 10 minutes to talk about their views of the hearing and what this is all about. Then we will have a panel to introduce Judge Barrett, and she will make an opening statement. We'll try to finish mid-afternoon if that's possible. Then Tuesday and Wednesday will be long days. There'll be 30-minute rounds for every senator, followed by a 20-minute round. My goal is to complete that Wednesday at some kind of reasonable hour in the evening. Thursday, we will begin the markup. I intend to hold it over and bring the committee back on the 22nd to vote on the nomination. So if I may, I'll start off with an opening statement and say, why are we here? Number one, Justice Ruth Bader Ginsburg died on September the 18th. What can you say about Justice Ginsburg? She was confirmed 96-3. Now, those were days that have since passed. I regret that. 96-3. Now, this was a person who worked for the ACLU, someone who was known in progressive circles as an icon. Apparently, just about every Republican voted for her. Her good friend on the court, Justice Scalia, I think got 97 votes. I don't know what happened between then and now. I guess we can all take some blame, but I just want to remind everybody there was a time in this country where someone like Ruth Bader Ginsburg was seen by almost everybody as qualified for the position of being on the Supreme Court, understanding that she would have a different philosophy than many of the Republicans who voted for her. 27 years on the court. Before becoming a member of the court, she was an active litigator, pushing for more equal justice and better rights for women throughout the country. Her close friend, until his death, Justice Scalia called her the leading and very successful litigator on behalf of women's rights, the Thurgood Marshall of that cause. What high praise. I can't say any more than that statement says. In my view, the person appearing before this committee is in a category of excellence, something the country should be proud of, and she will have a chance to make her case to be a worthy successor and to become the 9th member of the Supreme Court of the United States. On September the 26th, Judge Coney Barrett was nominated by President Trump to the Supreme Court. Who is she? She is a judge sitting on the 7th Judicial Circuit. She's highly respected. She was a professor at Notre Dame. 3 years during that tenure, she was chosen by the students to being the best professor, which I'm sure is no easy task at any college. She's widely admired for her integrity. She grew up in New Orleans, graduated from Rhodes College in Memphis, Tennessee in 1994, graduated summa cum laude and first in her class from Notre Dame Law School in 1997. So academically, she's very gifted. She clerked for Judge Lawrence Silberman on the U.S. Court of Appeals for the D.C. Circuit, and then for Justice Scalia on the Supreme Court. She practiced law in Washington, D.C. She joined the faculty at Notre Dame in 2002. She's published numerous articles in prestigious journals, including the Columbia, University of Virginia, and Cornell Law Review. She's been a circuit court judge at the 7th Circuit since 2017. She was confirmed to that position with a bipartisan vote. She has heard hundreds of cases in that capacity. She said, "I clerked for Justice Scalia more than 20 years ago, but the lessons I learned still resonate. His judicial philosophy is mine. A judge must apply the law as written. Judges are not policymakers, and they must be resolute in setting aside any policy views they might hold." She will give her statement, but I think that is a good summary of who she is. That's who Amy Barrett is in terms of the law. In terms of Amy Barrett, the individual, she and her husband have 7 children, 2 adopted. So 9 seems to be a good number. The process. This is an election year. We're confirming the judge in an election year after the voting has occurred. What will happen is that my Democratic colleagues will say, this has never been done, and they're right in this regard. Nobody's, I think, has ever been confirmed in an election year past July. The bottom line is Justice Ginsburg, when asked about this several years ago, said that a president serves for 4 years, not 3. There's nothing unconstitutional about this process. This is a vacancy that's occurred through a tragic loss of a great woman, and we're going to fill that vacancy with another great woman. The bottom line here is that the Senate is doing its duty constitutionally. As to Judge Garland, the opening that occurred with the passing of Justice Scalia was in the early part of an election year. The primary process had just started. And we can talk about history, but here's the history as I understand it. There's never been a situation where you had a president of one party and the Senate of another, where the nominee, the replacement, was made in an election year. It's been over 140 years ago. I think there have been 19 vacancies filled in an election year. 17 of the 19 were confirmed to the court when the party of the president and the Senate were the same. In terms of timing, the hearing is starting 16 days after nomination. More than half of all Supreme Court hearings have been held within 16 days of the announcement of the nominee. Stevens 10, Rehnquist 13, Powell 13, Blackmun 15, Berger 13. All I can say is that I feel that we're doing this constitutionally, that our Democratic friends object to the process. I respect them all. They'll have a chance to have their say. But most importantly, I hope we will know more about how the law works, checks and balances, what the Supreme Court is all about when this hearing is over. Why hold this hearing? A lot of people on our side say just ram it through. I hear that a lot. That's why I don't listen to the radio much anymore. So the bottom line is I think it's important. This is a lifetime appointment. I would like the world and the country to know more about Judge Barrett. I'm proud of you. I'm proud of what you've accomplished. I think you're a great choice by the president. This is probably not about persuading each other unless something really dramatic happens. All Republicans will vote yes and all Democrats will vote no. And that will be the way the breakout of the vote. But the hearing is a chance for Democrats to dig deep into her philosophy, appropriately ask her about the law, how she would be different, what's on her mind. It gives Republicans a chance to do the same thing. Most importantly, it gives you a chance, the American people, to find out about Judge Barrett. Judge for yourself. Is this person qualified? Is she as qualified as Sotomayor and Kagan? I think so. These were two nominees presented to the committee by President Obama. They had a different legal philosophy than my own, but I never doubted one moment that they were not qualified. I thought Gorsuch and Kavanaugh were qualified. The Senate in the past has looked at qualifications more than anything else. We've taken a different path at times. Bork, Thomas, Alito, Kavanaugh. I hope we don't take that path with Judge Barrett. She doesn't deserve that. I don't think it makes this hearing any better. And the American people, I believe, would not deserve a repeat of those episodes in the Senate Judiciary Committee's history. To my Democratic colleagues, I respect you all. We've done some things together, and we've had some fights in this committee. I've tried to give you the time you need to make your case, and you have every right in the world to make your case. I think I know how the vote's going to come out, but I think Judge Barrett is required for the good of the nation to submit to your questions and ours. This is going to be a long, contentious week. I would just ask one thing of the committee. To the extent possible, let's make it respectful. Let's make it challenging. Let's remember the world is watching. Senator Feinstein.
Thanks very much, Mr. Chairman. And I do want to just address your last statement. We feel the same way, and I believe we want this to be a very good hearing. And I certainly will strive to do my best to achieve that. Good morning, Judge Barrett, and welcome to you and your family. Less than 1 month ago, the nation lost one of our leading voices for equality. Ruth Bader Ginsburg left very big shoes to fill. Judge Ginsburg loved the law, and she loved this country. She worked all of her life to ensure that the opening words of our Constitution, "We, the people of the United States, in order to form a more perfect union," included all the people, not just a few, elite few. She was a standard bearer for justice. Justice Ginsburg's nomination was the first one that I participated in when I came to the Senate, and it was a real thrill to be part of that crowded and celebratory hearing for someone who had broken down barriers and reopened doors and staunchly believed in a woman's right to full equality and autonomy. In filling Judge Ginsburg's seat, the stakes are extraordinarily high for the American people, both in the short term and for decades to come. Most importantly, health care coverage for millions of Americans is at stake with this nomination. So over the course of these hearings, my colleagues and I will focus on that subject. We will examine the consequences if, and that's a big if, Republicans succeed in rushing this nomination through the Senate before the next president takes office. But most importantly, in just a few weeks, on November 10th, the Supreme Court will hear hearings in Texas v. California, a case brought to strike down the ACA. The President has promised to appoint justices who will vote to dismantle that law. As a candidate, he criticized the Supreme Court for upholding the law and said, and I quote, "If I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare," end quote. And when he appointed Judge Barrett to fill Justice Ginsburg's seat, the President said that eliminating the Affordable Care Act would be, quote, "a big win for the USA." Judge Barrett, you've been critical of Chief Justice Roberts for his 5-4 opinion upholding the law, stating that Roberts, quote, "pushed the Affordable Care Act beyond its plausible meaning to save the statute," end quote. This well could mean that if Judge Barrett is confirmed, Americans stand to lose the benefits that the ACA provides. So I hope you will clarify that in this hearing. First, more than 130 million Americans with pre-existing conditions like cancer, asthma, or even COVID-19 could be denied coverage or charged more to obtain health insurance. This includes more than 16.8 million Californians with pre-existing conditions. And we are just one state, but I think you should know how we feel. Secondly, some 12 million working Americans are covered through the ACA's Medicaid expansion. If the act is struck down, they lose their health care. Third, more than 2 million Americans under the age of 26 are covered by their parents' health insurance, and they could lose that coverage. Fourth, insurers could charge higher premiums for women simply because of their gender. And fifth, women could lose access to critical preventive services and maternity care, including cancer screenings and well-woman visits. Now, the bottom line is this. There have been 70 attempts to repeal the ACA, but clearly the effort to dismantle the law continues, and they are asking the Supreme Court to strike down the Affordable Care Act. This, I believe, will cause tremendous harm. Consider people like Christina Monroe Garcia of my home state. At age 60, Christina's eyesight started to fail because of cataracts. She had always struggled to obtain insurance because of pre-existing conditions, including C-sections and epilepsy. The cost of coverage, when it was even offered to her, averaged between $2,500 and $3,000 a month, far more than she and her husband could afford. In 2010, she was able to obtain coverage through the Affordable Care Act. Within weeks, she was able to have cataract surgery. This saved her life. Christina described her reaction when she was able to get coverage through the California Health Exchange following passage of the ACA. And let me quote, "It was like manna from heaven. I cried. After all these years of struggling to obtain coverage, I was able to get insurance through the California Exchange, no questions asked about my pre-existing conditions. The premium was worth $200 a month as compared to the $2,500 to $3,000 monthly payments I would have to pay before the ACA, if I could even get an insurer to offer me coverage." As Christina further explained, and I quote, "People just don't understand what it was like, the incredible fear before the Affordable Care Act, having to worry about being able to cover medical expenses and not being able to find affordable insurance," end quote. We can't afford to go back to those days when Americans could be denied coverage or charged exorbitant amounts. That's what's at stake for many of us, for America, with this nomination. And that's why the questions we will ask and the views, hopefully, that you will share with us are so important. We are now just 22 days from the election, Mr. Chairman. Voting is underway in 40 states. Senate Republicans are pressing forward, full speed ahead, to consolidate a court that will carry their policies forward with, I hope, some review for the will of the American people. President Trump said last week that he had, quote, instructed my representatives to stop negotiation over a COVID-19 relief package until after the election, end quote, and to, quote, focus full-time on confirming Judge Barrett to the Supreme Court. When Justice Scalia died in February of 2016, Senate Republicans refused to consider a replacement for his seat until after the election. At the time, Senator McConnell said the American people should have a voice in the selection of their next Supreme Court justice. When asked in October 2018 if Republicans intended to honor their own rule if an opening were to come up in 2020, Chairman Graham promised, quote, if an opening comes in the last year of President Trump's term and the primary process has started, we'll wait till after the next election. Republicans should honor this word for their promise and let the American people be heard. Simply put, I believe we should not be moving forward on this nomination, not until the election has ended and the next president has taken office. Thank you, Mr. Chairman.
Thank you very much, Senator Feinstein. Senator Grassley.
Welcome, Judge. On March 1, 2016, Justice Ginsburg delivered a eulogy for her friend, Justice Scalia. Justice Ginsburg said, quote, we were different, yes, in our interpretation of written text, yet one in our reverence for the courts and its place in the U.S. system of governance, end of quote. Justice Ginsburg's remarkable life and legacy will be honored for a generation, and also Justice Scalia's. The Senate is now tasked with carrying out perhaps its most solemn duty under the Constitution. As we go through this process, we should heed Justice Ginsburg's words with a shared reverence for the court and its place in our constitutional system. This idea of place in our system of government is critical. Ours is a government of separated powers. The power to make, enforce, and interpret law isn't centralized in one person or one branch of government. That's not a mistake. You all know what our American Revolution was all about and what the Constitution is all about, because people at that time were sick and tired of one person, George III, restricting American colonies of freedom that English-speaking people elsewhere exercised. As Justice Scalia reminds us, the framers recognized the separation of powers as, quote, the absolutely central guarantee of a just government, because without a secure structure of separated powers, our Bill of Rights would be worthless, end of quote. But this constitutional system only succeeds if each branch respects its proper role. A good judge understands it's not the court's place to rewrite the law as it sees fit. It's not his or her place to let policy, personal, or moral principles dictate an outcome of a case. We are fortunate. Judge Barrett's record clearly reflects this standard. She said, quote, "A judge must apply the law as written. Judges are not policymakers, and they must be resolute in setting aside any policy views that they might hold." End of quote. Judge Barrett's service reflects an exceptional intellect paired with deep commitment to the rule of law. So we look to those who know her well. She's received praise across the legal profession and ideological spectrum. Former colleagues at Notre Dame described the judge as, quote, "brilliant, industrious, gracious, and kind, and as a person of utmost integrity with an open mind and an even temperament that is prized in a judge," end of quote. She's also known as, quote, "a generous mentor." And she's known for her, quote, "her humility, graciousness, and her ability, born of her credibility, to build consensus among differing views," end of quote. Her students, quote, "expressed awe with the power of Judge Barrett's intellect, with her mastery and organization of complex material, and with her professionalism," end of quote. Leaders of more than 200 liberty-supporting groups across the country say Judge Barrett, quote, "possesses the judicial temperament and philosophy necessary as a bulwark for our Constitution and institutions of government," end of quote. 24 state governors describe Judge Barrett as, quote, "a woman of great moral character who is devoted to her country, community, family, and faith like many Americans," end of quote. The Wall Street Journal editorial board says, quote, "President Trump's nomination of Coney Barrett for the Supreme Court is the highlight of his presidency," end of quote. A promise kept, a promise made, a promise kept. Liberal Harvard law professor Noah Feldman called Judge Barrett, quote, "a principled, brilliant lawyer, a genuine and good person, highly qualified to serve on the Supreme Court." That's a pretty high praise. I just recited from others. Moreover, Judge Barrett is a tireless mother of 7. For decades, I've led efforts in the Senate to improve foster care and promote adoption. So it's a privilege for me to welcome a justice like that to the Supreme Court. To sum up, Judge Barrett's qualifications and character are impeccable. Unfortunately, I expect the minority will try to rustle up baseless claims and scare tactics as they've done for decades, anything to derail the confirmation of a Republican nominee. Lately, the left is threatening to pack the Supreme Court in retaliation for this confirmation process. Even the Democrats' nominee for president and vice president have not ruled out such blatantly partisan policy grabs. Republicans are following the Constitution and the precedent. It seems Democrats would rather just ignore both. The left is also suggesting Judge Barrett's confirmation would be the demise of the Affordable Care Act and the protection for pre-existing conditions. That's outrageous. As a mother of 7, Judge Barrett clearly understands the importance of health care. So let's set the record straight. Then Professor Barrett criticized Chief Justice Roberts' conclusion that the Affordable Care Act penalty was actually a tax. Democrats say her viewpoint is radical and a preview of how she might vote on the court. First, her comments dealt with a provisional law that's no longer in effect. So the legal questions before the court this fall are entirely separate. Moreover, her criticism of Roberts' reasoning is mainstream, not only in the conservative legal community, but well beyond. I'm the chairman of the Finance Committee and was ranking member when Democrats unilaterally cobbled together Obamacare. I know a tax when I see one. This wasn't a tax. It was never discussed in committee as a tax. Even the Democrats who forced it through Congress insisted it wasn't a tax. Jeffrey Toobin wrote that Roberts' tax argument was, quote unquote, not a persuasive one. President Obama even said, quote, I absolutely reject the notion that it was a tax. Further, Democrats and their allies shouldn't claim to know how any judge would rule in any particular case. Just look at history. The left slammed Stevens for his consistent opposition to women's rights. They called Anthony Kennedy sexist and a disaster for women. They said David Souter would, quote, end freedom of women in this country. Ultimately, the left praised these very justices that they attacked. Their doomsday prediction failed to pan out. Democrats and their leftist allies have also shown that there is no low that they won't stoop to in their crusade to tarnish a nominee. And I saw it all as chairman of this committee when Kavanaugh came up. Some of my colleagues may once again try to misrepresent and outright disparage Judge Barrett's religious beliefs and affiliations. In 2017, they suggested Judge Barrett was too faithful or too Catholic to be a judge. One senator asked whether she considered herself an Orthodox Catholic. Another told her, the dogma lives loudly within you, and that is of concern. Let me remind everyone that Article 1 clearly prohibits religious tests for serving in public office. Mr. Chairman, I got 5 sentences left. Judge, you'll no doubt be asked how you'll rule on questions and issues and whether the case was correctly decided. I expect that you'll follow the example of Justice Ginsburg. A nominee should offer no forecast, no hints of how he or she will vote, because that's the role of a judge. That's the place of a judge in our system of government. Unbiased, fiercely independent, faithful to the rule of law, and a steadfast defender of the Constitution. Judge Barrett, I look forward to our conversation. Once again, congratulations.
Thanks, Senator Grassley. I believe Senator Leahy will now join us virtually.
Thank you. And I assume you can hear me all right?
Yes, sir. And we see you. There you are. Thank you.
Thank you. You know, as I listen to this, I think about the fact that I've served in the Senate for 46 years. During that time, we had 20 Supreme Court nominations, 16 confirmation hearings, and I can tell you right now, none looked anything like this. We're less than 2 weeks from Justice Ginsburg being laid to rest. Now, it's true, it's the responsibility of this committee to consider her replacement on the Supreme Court, but this isn't the way we should do it. We should not have had a nomination ceremony before Justice Ginsburg was even buried, while the nation was mourning her passing. We should not be holding a hearing just 16 days later, when this committee has afforded itself 3 times as long to vet other modern nominees to our nation's highest court. We shouldn't be holding a hearing 3 weeks from a presidential election, when millions of Americans have already voted. Not when doing so requires that literally half of the Senate goes back on their word. Think of that, my Republican colleagues. Literally half of the Senate had to break their word, contradicting every argument they made 4 years ago about the American people needing a voice during election year vacancies. We should not be holding this hearing when it's plainly unsafe to do so. 2 members of this committee are just now emerging from quarantine after testing positive for COVID. And when other members have declined to get tested, and the chairman has refused to implement a daily testing regime to keep members and staff and Judge Barrett and her family safe. And I might say we shouldn't be spending time on this when we're doing absolutely nothing to pass a much-needed COVID bill. Every senator on this committee knows in their heart this total break with precedent, break with their commitments is wrong. More than 212,000 Americans have died due to COVID, millions more are hurting. The virus is spiking again across the country, but Senate Republicans have nothing to say about that. The Senate is wearing blinders to the grim realities facing Americans. Instead of talking about COVID and doing something to help the American people, we're engaged in this mad rush to fill a Supreme Court vacancy on the eve of a presidential election. And why? I think the answer is painfully clear. With this vacancy, President Trump and Senate Republicans see the potential to wildly swing the balance of the court. They see the ability to take the courts from being independent to making them instead an arm of the far right in the Republican Party. The potential to accomplish through the courts what they failed to accomplish by votes in the halls of Congress. And the top of their hit list is the Affordable Care Act. It's no secret, it's no coincidence that Republicans are rushing to confirm Judge Barrett before the Supreme Court considers the latest Republican-led lawsuit to overturn the Affordable Care Act on November 10th. The president has even promised that any judge he nominates will overturn the Affordable Care Act. One member of this committee has promised he won't vote for a judge unless he has that commitment that the nominee will overturn the act. And for her part, Judge Barrett's writings have made it unequivocally clear she considers the act unconstitutional. In fact, overturning the Affordable Care Act has been perhaps the single most important policy objective of the Republican Party during the past decade. And if Republicans are now successful, the results will be nothing short of catastrophic for the millions of Americans who depend upon its coverage and projections. These are real people. You may have, I believe you have in the committee, and I'm trying to get this so you can actually see it. This is Mary Naden Scott. She lives in Northfield, Vermont. That's just over the ridge from my home in Middlesex, Vermont. In her 20s, Mary was diagnosed with Friedreich's ataxia, a rare neurological disease. Like my wife, Marcelle, and I apologize for, I know you have this picture in the committee room. Mary worked as a nurse, realizing she would soon no longer be able to pursue the career she loved. She asked the hospital to rotate her through different specialties so she could help more people in as many ways as possible. That's who she is. And now she's in a wheelchair. She can no longer practice nursing. She does everything she can to take care of her two children. I actually had the pleasure of calling one of her sons on his birthday last spring. And Mary, I know, attends their soccer games. She helps with their remote school. She even brought them to tour the Vermont State House. Now, Mary can do this because her medication and in-home care is paid for by her insurance. But she's worried. Even with some state protections, she's worried what the Supreme Court case next month will mean for people with pre-existing conditions like her. For Mary, if she lost her insurance, her biggest worry is she'd lose her in-home support that allows her to continue living at home and taking care of her children. Now, she's a fighter. And when I think of what the Affordable Care Act means to millions of Americans, what's on the line with this nomination? I think of Mary. I think of what she's going to lose. And she's not the only one. You know, I talk to Vermonters all the time. Now think of another one, Martha Richards. She is an amazing, amazing woman. She's another Vermonter who reached out to my office concerned about the fate of the Medicaid expansion under the Affordable Care Act. Martha earns just over the minimum wage in Vermont. She works for the Vermont State Parks, and she's raised 2 kids on her own. Just look at this person. Soon after rolling now in the expanded Medicaid program, she began experiencing debilitating pain in her ear behind her eye. It led to a series of expensive medical tests, including 2 MRIs. It would cost $6,000 each. She shudders. The thought what would have happened without the Medicaid expansion. If it's discarded now, as Republican attorneys general have requested a case before the Supreme Court, millions of Americans like Martha would be on their own. Now, I do not suggest that Judge Barrett personally desires these consequences or personally desires to devastate the lives of these 2 Vermonters. Far from it. But these are nonetheless the consequences if her stated views on the law prevail in the Supreme Court, and if Republicans are successful in filling this vacancy prior to November 10th. Well, then we know these views will almost certainly prevail. So that's what's at stake here. That's what weighs heavily on me as we begin these hearings. It also weighs heavily on the minds of the Vermonters I represent. I've heard from them often and loudly since Justice Ginsburg's passing. They're scared, Judge Barrett. They're scared that your confirmation would rip from them the very health care protections the millions of Americans have fought to maintain, and which Congress has repeatedly rejected eliminating. They're scared that the clock will be turned back to a time when women had no right to control their own bodies, and when it was acceptable to discriminate against women in the workplace. They're scared that at a time when we are facing the perilous impacts of climate change, bedrock environmental protections are going to be eviscerated. And they're scared that your confirmation would result in the rolling back of voting rights, workers' rights, and the rights of the LGBTQ community to equal treatment. These aren't just thoughts. These are real-life implications of decisions made by the court. And a majority of Americans, like an overwhelming majority of my fellow Vermonters, don't support taking our country in that direction. Now, Republicans first announced their intention to fill Justice Ginsburg's seat just 1 hour after her death. From that moment, this process has been nothing but shameful. Worse, it will almost certainly lead to disastrous consequences for Americans. Justice Ginsburg, I am certain, would have dissented, and I will too, on behalf of Vermonters, on behalf of the integrity of the Senate, and on behalf of the majority of Americans who oppose this process. Thank you.
Thank you, Senator Leahy. Senator Cornyn.
Thank you, Mr. Chairman. Judge Barrett, welcome to you and your family. The Senate Judiciary Committee undertakes no more important duty than the one we undertake today, considering the nomination for a seat on the United States Supreme Court. As the chairman said, these used to be routine. Even the 2 justices who were once considered the ideological bookends on the court received overwhelming support in the Senate. While the 2 justices had a different judicial philosophy and were nominated by presidents of opposing parties, the Senate used to recognize that exceptional qualifications were all that was required for a seat on the court. Throughout your impressive career, you've earned the respect of those who share your views on the law, as well as those who do not. As Justice Ginsburg said of her unlikely friendship with Justice Scalia, You can disagree without being disagreeable. But I don't want to imply that you disagree frequently. In fact, during your time on the Seventh Circuit, you've sided with your colleagues more than 95% of the time. And when you've had the rare disagreement, your opinions attack the ideas, not the person. We could use more of that. Your collegiality has been demonstrated in the numerous letters pouring in from your colleagues, clerks, students, virtually everybody with whom you come in contact. Folks with widely different judicial philosophies agree that you are brilliant, respectful, kind, and when you disagree, you do so without personal rancor or malice. While your qualifications and reputation are on par with those justices who have sat in this seat before you, the political climate in which you are being vetted is quite different, as we all know. What our colleagues on the other side of the aisle put Justice Kavanaugh through 2 years ago was an absolute disgrace and hopefully a low point for the Senate. They and some of their allies sought to destroy the personal character of a good man with innuendo, misinformation, and outright lies. I hope they resist the temptation to repeat that during this hearing. I do remain concerned, Judge, about some of the earlier attacks on your faith. In a recent Wall Street Journal column, a Wisconsin Supreme Court justice wrote, to put it bluntly, America's secular cultural elites aren't sure that a faithful Christian can be entrusted with the law. A former senior aide to former Majority Leader Harry Reid recently said the groups want blood. Democrats on and off the committee want a real fight. But let me be clear, Judge, as you know, there's no religious test to serve on the Supreme Court. Why? Because the Constitution says so. And I can only hope that the civility that you've shown through your professional work will be afforded to you through these proceedings. But Judge, there's a question that comes up in my discussions with my constituents that's really more basic and more personal. They want to know how you do it. How do you and your husband manage 2 full-time professional careers and at the same time take care of your large family? I'll bet there are many young women, like my own 2 daughters, who marvel at the balance that you've achieved between your personal and professional life. As is customary and important, I also look forward to revisiting the appropriate role of judges in our constitutional republic, something that you can see there appears to be some dispute about here. You and I both know that judges should not be policymakers. But could it be that one of the reasons these confirmation hearings have become so contentious is because some Americans have given up on the idea of fair and impartial judges who do not pick winners and losers, that they've given up on an independent judiciary? I hope not. Judges should not be unelected super legislators, giving their political allies wins they could not secure through the rough and tumble of the political process. Our founders, through the Constitution, provided that judges would be independent of political pressure. Chief Justice Roberts reminded all of us recently that we do not have Obama judges or Trump judges, Bush judges, or Clinton judges. And ideally, that is true. You've said judges constrain themselves by making a choice to follow the law where it leads, trying to check their own preferences at every turn. In the end, a judge's internal compass, her commitment to the rule of law, rather, is the most important constraint upon any sort of judicial willfulness. But you're being asked to abandon that, Judge. You stand accused of intending to violate your oath before you even take it. Further, our Democratic colleagues want you to guarantee a result in a case as a quid pro quo for your confirmation. It's outrageous. Well, they've said that if this confirmation proceeds, they intend to pack the court with more justices who will turn the Supreme Court into a genuine second legislative body. We heard what Justice Ginsburg had to say about that. That would be a terrible mistake. Judge Barrett, I'm confident that at the end of this hearing, your stellar character, credentials, and body of work as a judge will demonstrate that you understand the limited but important role of the judiciary under our Constitution. I'm confident that you will demonstrate that you will faithfully and fairly interpret the text of the law and the Constitution and dutifully apply them to the disputes that come before you. And I'm confident that at the end of this process, you will be confirmed to the United States Supreme Court.
Senator Durbin.
Thank you, Mr. Chairman. Judge Barrett, your family, welcome. We are at a critical moment in our nation's history, in the throes of a devastating pandemic, with over 216,000 Americans dead and over 7.7 million infected with this virus. Each day, we are reminded of how this invisible virus has changed our lives and changed America. And there is no end in sight. We face an economy in crisis with millions of jobs lost and crushing challenges facing workers, businesses, families all across America. And we're in the middle of an election season. Millions of Americans have already cast their votes. And this may be one of the most consequential elections in our nation's history, because for the first time in the history of the United States, an incumbent president refuses to commit to a peaceful transition of power if he loses the election. This president, in his vanity and constitutional recklessness, refuses to commit to accept the will of the American electorate. And of course, we're still in the process of mourning the loss of an historic champion of justice and equality, Ruth Bader Ginsburg. Justice Ginsburg spent her entire life and every ounce of strength and talent she was given in the pursuit of America's highest ideal, equal justice under the law. Her absence is deeply felt. Now, this is the context in which the Senate majority Republicans are defying the traditions of the Senate and rushing forward with President Trump's third nomination to the U.S. Supreme Court. It has been recounted earlier that Justice Ginsburg was approved by the Senate by a 96-3 vote. This icon of liberal thinking, advocate for the ACLU, 96-3 before the United States Senate, and then Anton Scalia, on the opposite polar end of the political spectrum, approved 98-0. Amazing. Can this be the same Senate? It's not. The reason those votes were so overwhelming was because people lived by the rules, they lived by the traditions of the Senate, and they had mutual respect for one another. We know now that this process does not adhere to those guidelines. The haste in this pursuit that before us today is unfair to the Senate and unfair really to the nominee. The nominee before us was announced 16 days ago, the day after Justice Ginsburg lay in state in the United States Capitol. We received the nomination paperwork 13 days ago and have learned since then that some materials are missing. The speed with which Republicans are moving to fill this vacancy stands in sharp contrast to the approach taken by the same Senate Republicans the last time there was a vacancy in an election year in 2016. Behind me is the McConnell Rule. On February 13, 2016, when Justice Scalia passed away, Senator McConnell said, and I quote, "The American people should have a voice in the selection of their Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president." This rock-solid statement of principle was made 269 days before the 2016 election. The Republican members of this committee fell obediently in line behind Senator McConnell's statement of principle. They even sent a letter on February 23, 2016, and I quote, This committee will not hold hearings on any Supreme Court nominee until after our next president is sworn in. The letter noted that, quote, the election is well underway, that was 269 days before the election, and said the decision was, quote, born of a necessity to protect the will of the American people. Yet when Justice Ginsburg passed away on September 18th this year, Senator McConnell said that very same night, and I quote, President Trump's nominee will receive a vote on the floor of the United States Senate. He made this statement a mere 46 days before the election. People had already begun casting votes, and my Republican colleagues marched in front of the cameras, looked down at their shoes, dutifully reversed their positions, and lined up obediently behind their leader again. It gets down to this. Either the American people do get an election year voice regarding a vacancy on the Supreme Court, or they don't. In 2016, Senator McConnell said, give them a voice. Now he says, don't give them a voice. It is a shameless, self-serving, venal reversal. Why are Senate Republicans so afraid to give the American people a voice about the future of the Supreme Court? First, they must doubt that Donald Trump will be reelected. Second, they want a 6-3 Supreme Court to carry out a Republican agenda that's really not very popular with the American people. And there are 2 dates on the calendar which explain their timetable, November 3rd and November 10th. We know November 3rd is Election Day. President Trump has made it clear he wants another of his appointees on the Supreme Court before the election because he anticipates court challenges over the vote, especially over mail-in balloting, which he has repeatedly attacked without any substance. President Trump has indicated he'd be perfectly happy to have a close election decided by a 6-3 conservative majority Supreme Court rather than by the votes of the American people. The other date, of course, is November 10th. We know that date well on this committee. That's the date the Supreme Court will hear oral arguments in California versus Texas. This is the case in which the Trump administration is urging the court to strike down the entire Affordable Care Act, including protections for tens of millions of Americans with pre-existing conditions. It's unimaginable that in the midst of a pandemic, the Republicans want to strike down a law that 23 million Americans rely on for their personal health insurance and millions more for the protections given to the writing of future insurance policies. On September 27th, President Trump tweeted he wants to see the Affordable Care Act, quote, terminated in the Supreme Court. Let's be very honest about this. This president has never suffered an unuttered thought. He gives us 25 tweets a day to tell us what's going through that fertile mind. We know what he thinks because he tells us what he thinks. And he made it clear that he wants his Supreme Court and this nominee to join him in eliminating the Affordable Care Act. This is his litmus test. How many times have we heard it? How many times have we heard his criticism of Chief Justice Roberts for failing to strike down Obamacare? When he was running for president, then candidate Trump tweeted, quote, if I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee John Roberts on Obamacare. Think it would mean what it would mean if the Republicans wished to strike this down. All the people who would lose their coverage, which we have heard recounted repeatedly this morning and will hear even more. Republicans in Congress have been obsessed with repealing Obamacare for years, but they don't have the votes to do it. They couldn't get it done in the House. They couldn't get it done in the Senate, thanks to 3 brave Republicans, including John McCain. And now they've got to rely on the court to do their work. Judge Barrett, you're on the record. You wrote an article in which you criticized the NFIB versus Sebelius case, where Chief Justice Roberts was the deciding vote upholding the ACA. Now your nomination is moving forward at unprecedented speed. So what's at stake? Let me show you what's at stake here. I want you to meet Kenny Murray from Tinley Park, Illinois, and his family. Last year, I had a privilege of meeting the family in my Washington office. Here's a picture of Sue, Ken, their daughter Maddie, and their son Kenny. Sue and Kenny Murray told me that their son Kenny was diagnosed in utero with multiple complex congenital heart defects. Before his first birthday, Kennedy had 2 open-heart surgeries at Advocate Children's Hospital outside of Chicago. He had surgery for the 3rd time at 14 months of age. 4 months in his young life, he was staying in the pediatric ICU, and his health bills had reached $1 million. When Kenny was born in November 2013, his dad's health insurance through his employer had a lifetime maximum cap of $1 million. Thankfully, the Affordable Care Act banned insurance companies from imposing these annual lifetime limits, including on employer-sponsored health insurance. That ban went into place in January 2014, 6 days before Kenny's first surgery. If it weren't for the ACA, Sue and Ken would have hit the lifetime limit for Kenny in just 4 months. They told me they would have gone bankrupt. Thanks to the Affordable Care Act, Kenny was able to get the care he needed. This last picture I want to show you, well, here it is. Wouldn't you want him on your team? I sure would. When she gave permission for me to share Kenny's story today, his mom, Sue, said, quote, "Kenny is a real person whose life depends on the Affordable Care Act." Judge Barrett, your nomination for a lifetime appointment to the highest court in the land comes before us under a cloud. You have been nominated by a president who shows contempt for the Constitution, but does not hesitate to tell his loyal followers that you are being sent to the bench to do his political chores, abolish the ACA, rule in his favor on any election contest, and even more. You cannot feel good about a president cheapening this historic moment. The future of the Affordable Care Act and so many other issues hang in the balance. Voting rights, civil rights, the right to privacy and choice, environmental protection, gun safety laws, marriage equality, dreamers, work protection. These are the stakes. If we wait just a few more days, we'll know what the American people have to say.
Thank you, Senator Durbin. Senator Lee, welcome back.
Thank you, Mr. Chairman. Welcome, Judge Barrett, and welcome to your family as well. Judge Barrett, you and I have a number of things in common. We're both raised in large families. In fact, we're both one of 7 children. In your case, as I recall, you're the oldest of 7 children, which means that long before you had your own 7 children, you were also the de facto mother to many others. The way things often work in large families is such that the oldest child very often takes on responsibilities at an early age. Those responsibilities have undoubtedly helped you throughout life, establishing leadership roles in your career as a lawyer, as a professor, and now as a judge. Those leadership roles, of course, mean something different in the judicial branch of government than they do in the executive branch or in the legislative branch of government. We've heard this morning a number of arguments that are essentially policy arguments, many of them geared toward actual policies, in some cases, actual pieces of legislation. We have to remember that we've got 3 distinct branches of government within our system. We've got 2 that are political, the legislative branch, where we work, where we make laws, the executive branch, headed by the president, where the laws are executed, implemented, and enforced, and of course, the judicial branch, where you work, where the laws are interpreted, where people come to disagreement as to their meaning. The branches are sometimes referred to as equal. I don't think this is the best description of them. I think the best description of them is that they are coordinate branches of government, meaning they each exist within their own sphere. They're not equal in the sense that the least dangerous branch was, is, always has been, and always will be the judicial branch, for the simple reason you can't reach out. You can't decide where we're going to go today or tomorrow. The judiciary is confined solely to those cases and controversies brought before your jurisdiction. You look not into the future, but in the past. You see the world, as it were, through a rear-view mirror. Your job is to decide what the law says when people disagree as to the law's meaning. Those laws consist of words. Those words used in a particular combination, in a particular context, had a particular meaning on the day of their enactment or their incorporation into the Constitution, and that's your job. And yet, if you were watching today's hearing, and some of the statements made by some of my colleagues, in fact, if you were to look at any of the countless posters put up in here, you'd think that this was a political discussion, a policy discussion, a legislative discussion. You, in fact, are not being reviewed for a legislative position or a policy-making position. you're being reviewed for a position on our nation's highest court, where you'll be asked from time to time to decide cases based on the law, based on the facts. This is not something that should result or properly should be considered by us as something that requires us to examine whether, to what extent, in what way you have compassion for any of the individuals depicted in these photos. I'm certain, just based on my limited interaction with you, that you have compassion for all people. But this isn't the question, nor is the question before us whether you would agree or disagree as to any particular policy embedded within any particular statute. You understand that this isn't your job, not as a judge on the U.S. Court of Appeals for the Seventh Circuit where you now sit, nor would it be if you were to be confirmed as an Associate Justice to the United States Supreme Court. One might also have the impression, from watching this morning's proceedings so far, that the Supreme Court of the United States is a remarkably bitter, cynical, and overwhelmingly partisan place. It is not. You and I have both clerked at the U.S. Supreme Court, and we both know that you actually look at the numbers, you'll see something remarkable. Despite its flaws, and despite the fact that it sometimes makes mistakes, the Supreme Court of the United States sits atop something that is the envy of the entire world. A judicial system that, despite the fact that it's run by human beings and therefore is imperfect, is the best judicial system that has ever existed on planet Earth. One of the many ways in which this is manifested is when you look at the 9 members of the Supreme Court and the fact that they come from different backgrounds. They've been appointed by different presidents. They've come at it with somewhat different judicial philosophies, to the extent that some of them have indicated what their political leanings might be. They indicate that they come from different political backgrounds as well. And yet, the most common configuration of a Supreme Court decision is not 5-4. It's not even 6-3. It's, in fact, 9-0, 8-1, and 7-2 make up the vast, overwhelming majority of all Supreme Court decisions. Now, this is especially remarkable when you consider the fact that the Supreme Court typically takes up only those cases, those rare cases, as to which lower courts have been unable to reach an agreement when interpreting the same finite provisions of federal law, a federal statute, or a provision of the United States Constitution. Multiple lower courts, very smart men and women from around the country, highly specialized, skilled in their trade, have been unable to reach the same conclusion as to the meaning of the same group of words. Then and only then does the Supreme Court tend to take up those cases. And yet, the Supreme Court overwhelmingly decides those cases either unanimously or near unanimously. And without these partisan divisions that one, from watching this hearing, would think is the bread and butter of the Supreme Court's work. The 5-4 configuration is actually relatively rare. When it does arise, it's not even always involving a hot-button political issue. Most of the Supreme Court's docket doesn't even consist of the hot-button issues. A whole lot of it consists of stuff that I find really, really fascinating, like the Dormant Commerce Clause. I mean, what American doesn't sit up late at night and stew over whether it's okay for a state or a political subdivision thereof to treat an article of commerce differently based on its origin or destination out of state or outside the United States? This, of course, is the kind of case that comes before the Supreme Court and might from time to time be decided on a 5-4 basis, but not necessarily along the lines that one would predict based on the appointment of each justice and the political party of each justice's appointing president. There are, of course, some decisions that are politically charged and that Americans do worry about more than others, that might affect more Americans, let's say, than a decision about waste disposal in the context of the Dormant Commerce Clause. I understand that. I get that. But there, too, we can't overstate or overplay the role the Supreme Court of the United States might exert. in that context. Even in those circumstances, when the Supreme Court rules that something has been done in a way that's not constitutional, it doesn't mean that that's the end of the policy road there. Sometimes it might mean the wrong government acted. Sometimes it might mean that the federal government acted where a state should have, or the other way around. Other times it might mean that the wrong branch of government acted. Other times it might mean that they went about it the wrong way. There's nearly always another way around a particular policy concern. Whether we are talking about health care, whether we're talking about privacy and individual liberty, each and every person serving anywhere in our government has an obligation to look out for the best interests of those they represent. In fact, each and every person serving as an officer of the United States government is required under Article 6 of the Constitution to take an oath to uphold and protect and defend the Constitution of the United States. The Constitution, in short, this document, written nearly 2.5 centuries ago, it has helped foster the development of the greatest civilization the world has ever known, is not just a judicial thing. This is a thing that works, and works best when every one of us reads it, understands it, and takes and honors an oath to uphold it and protect it and defend it. When we do our jobs in this branch, when our friends in the executive branch do their jobs, it requires us to follow the Constitution just the same way. These tactics of creating fear and uncertainty and doubt, these tactics that result in relentless protests outside of the one branch of government that isn't political, astound me, but they dismay me and they disappoint me. They reflect the fact that we have allowed for the politicization of the one branch of the federal government that is not political. We can turn that around. We ourselves, within the legislative branch, have got to do a better job by focusing on the fact that the Constitution is not just a judicial thing. It's also a legislative thing. It's also an executive thing. It's an American thing. It's one of the many reasons why I will object anytime anyone tries to attribute to you a policy position and hold you to that. You're not a policymaker, you're a judge. That's what we're here to discuss. Thank you very much, Mr. Chairman.
Well, definitely some good news. Senator Lee's enthusiasm for the dormant Commerce Clause convinces me you've made a full recovery. Senator Whitehouse.
Mr. Chairman, Judge Barrett, America's worried about one thing above all else right now, and it's our health. This hearing itself is a microcosm of Trump's dangerous ineptitude in dealing with the COVID pandemic. Trump can't even keep the White House safe. Here it's the chairman's job to see to the committee's safety. And though his words were reassuring, I don't know who has been tested, who should be tested, who is a danger. What contact tracing has been done on infected and exposed senators and staff? Nothing. The whole thing, just like Trump, is an irresponsible botch. The irony is that this slapdash hearing targets the Affordable Care Act. This Supreme Court nominee has signaled in the judicial equivalent of all caps that she believes the Affordable Care Act must go and that the precedent protecting the ACA doesn't matter. The big secretive influences behind this unseemly rush see this nominee as a judicial torpedo they are firing at the ACA. So I hope Republicans consider what's at stake for the many people who depend right now in this pandemic on ACA health coverage. Rhode Islanders are calling, writing, emailing, tweeting me by the thousands, asking me to say no to this nominee, mostly because they too see her as a judicial torpedo aimed at their essential protections. And my constituents want you, my colleagues, members of the Republican Party, to stand up for once to Mitch McConnell and to the big donors who are driving this process, and for the sake of regular people, say stop. Here's one person to consider, Laura, from North Smithfield, Rhode Island. Laura's brother saved her life when he donated one of his kidneys to her. The hereditary nephritis Laura battled was a pre-existing condition, protected under the ACA, just like COVID is now a pre-existing condition for nearly 8 million Americans. Laura tells me, without the ACA and its protections for people with pre-existing conditions, insurance premiums, if I'm able to get insurance at all, will be financially out of reach for me, and I will no longer be able to afford the health monitoring, labs, specialist appointments, and treatment that are essential for my kidney to function. My immunosuppressive medications alone would cost about $48,000 annually. Before the ACA, patients like me experienced times when they would come up against a life-threatening wall, not in treatment, but in the annual or lifetime caps on coverage insurers were allowed to impose. I can't imagine what this would have meant for me, bankruptcy or worse. Laura's not alone. We're in the midst of a relentless, deadly health crisis that Trump has botched, which touches nearly everyone in this country. Americans are dying by the hundreds of thousands. Our economy is down 10 million jobs. Despite all the warnings and all the desperate pleas for help, people on the front line, healthcare workers, teachers, first responders, police officers, countless others, still struggle for the resources they need. More and more small businesses are closing for good. Many hospitals teeter at the edge of insolvency. Rhode Island, like so many other states, faces cruel fiscal challenges brought on by this pandemic. Since May, the House has passed 2 major COVID relief bills to tackle unemployment insurance, aid to the front lines, help to small business, support for hospitals, support for states and localities, and plenty more. Mitch McConnell's Senate Republicans won't budge. No urgency, he said. But 80 minutes after we learned of Justice Ginsburg's death, Mitch McConnell signaled he would fill this vacancy. The White House chose a replacement 3 days later. Justice Ginsburg hadn't been buried when the President and Senate Republicans celebrated Judge Barrett's nomination at the White House super spreader event. This was a hypocritical, tire-squealing 180 for many Republican colleagues. When they blocked Merrick Garland, we heard nonstop about the importance, before an election, of the American people weighing in at the ballot box. Nonstop that you shouldn't have a nominee appointed to the court after the primary season had begun. Well, now, with Americans voting right now in the general election, we get this mad slapdash rush. Why? Look at the Supreme Court calendar. Exactly 1 week after the election, on November 10th, the Supreme Court is going to hear California v. Texas, a constitutional challenge to the ACA. It survived its last challenge by 1 vote. If the new challenge succeeds with a new justice, the case will tear out the ACA, the law on which over 20 million Americans rely for health insurance, through which 17 million Americans access Medicaid coverage, under which 129 million Americans get pre-existing conditions covered, under which millions of seniors enjoy lower drug costs. Gone. And make no mistake, this nominee's signals on the ACA and on respect for the ACA precedent are clear enough to move her to the top of the big donors list. Just 3 years ago, she wrote that Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. In 2013, she wrote that stare decisis is not a hard and fact rule in the court's constitutional cases, the ACA being a constitutional case. Clear signals that are likely why she's before this committee now. So back to Laura. With stories like Laura's coming in from around the country, why would we rush forward? Well, the answer isn't pretty. There's a promise to big donors that must be kept. When David Koch ran for vice president, he campaigned on getting rid of Medicare and Medicaid. Imagine his fury when Obamacare passed. His groups are spending millions right now on this nomination. Republicans in Congress tried and failed to repeal the ACA more than 70 times. It's in the Republican Party platform for justices to reverse the ACA decision. Trump has over and over said this is his reason. And now we're in this mad rush to meet the November 10th argument deadline. And colleagues pretend this isn't about the ACA. Right. The travel of the ACA case leads to one senator's doorstep. In a Politico article yesterday, the senior senator from Texas tried to say that this rushed process isn't targeting the ACA. But look at the record. The district judge in Texas who struck down the ACA in the case, now headed for the court, is a former aide to the senator, who's become what the Texas Tribune calls the favorite for Texas Republicans seeking big judicial wins like torpedoing the ACA. The senior senator from Texas introduced in committee the circuit court judge who wrote the decision on appeal striking down the ACA. Senator Cornyn has filed brief after brief arguing for striking down the ACA. He led the failed Senate charge to repeal the ACA in 2017. He said, "I've introduced and co-sponsored 27 bills to repeal or defund Obamacare and have voted to do so at every opportunity. And now, talking about socialized medicine, the old Republican battle cry against Medicare, Senator Cornyn and all of our colleagues on this committee are pushing to get this nominee on by November 10th, the time needed to strike down the Affordable Care Act." Please don't tell us this isn't about the Affordable Care Act. From Cornyn judge to this nominee, hop, hop, hop. When Texans lose their ACA health care protections, hop, 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 to see whose doorstep that sits on. Lost in this hypocritical rush is the legacy of Ruth Bader Ginsburg. Let me close by remembering her for a minute in this unseemly charade. She fought for equality, equity, and dignity. She forged a path for women in the law, to Harvard Law School, to the pinnacle of legal academia, to the apex of legal advocacy, and on to the Supreme Court, where she defended women's reproductive rights, Gonzalez v. Carhart, the rights of workers, Ledbetter v. Goodyear Tire and Rubber, voting rights, Shelby County v. Holder, the rights of immigrants, Homeland Security v. Regents, and countless other freedoms. In her work, she bent the arc of the moral universe toward justice for all Americans. How fitting that she should be the first woman to lie in state in our United States Capitol. As to this charade, big donors may love it, but Americans see what's going on. They see this ugly, hasty, hypocritical power grab, and they know what it means for their health care in the midst of a pandemic. For Republicans, there is no washing your hands of responsibility for the results that your president has told us will ensue. Thank you, Mr. Chairman.
Thank you. Senator Cruz, I think, is with us virtually. Is that correct?
Yes, Mr. Chairman.
All right.
Thank you, Mr. Chairman. Good morning. Welcome to Judge Barrett. Welcome to your family. Welcome to your beautiful children who are here with you today. You know, I want to start by making some observations about what we've heard this morning. At the very beginning, let me observe, as Sherlock Holmes famously observed, that what speaks the loudest is the dog that didn't bark, which is, to date, of every Democrat who's spoken, we've heard virtually not a single word about Judge Barrett. We've heard a lot of attacks at President Trump. We understand our Democratic colleagues are not supporters of the president. We've heard a lot of political rhetoric. We just heard the senator from Rhode Island directing some attacks at Senator Cornyn from Texas, and I understand there's an election in a few weeks, so that those political attacks are not surprising. But we've heard very little about the nominee who is here and whose confirmation we're considering. And I think part of the reason for that is that on any measure, Judge Barrett's credentials are impeccable. This is a woman who graduated #1 in her class at Notre Dame Law School. I'd venture to say that there is likely not a single member of this committee who graduated #1 in their class in law school. Perhaps my colleague Mike Lee can disagree with that statement, but it is a very impressive accomplishment. Judge Barrett went on to be a clerk to the great Justice Antonin Scalia, one of the greatest justices ever to serve on the Supreme Court. We heard celebration from Senator Leahy about the fact that he was confirmed 98-0. From there, she became a law professor for 2 decades at Notre Dame Law School, teaching the law to her students where she was beloved, where she was respected, where she was a serious, careful scholar. And now she is one of the most respected federal court of appeals judges in the country. None of the discussions from our Democratic colleagues addressed any of that, because those credentials are on their face impeccable. Indeed, the American Bar Association, which typically leans hard left and has a long pattern of favoring Democratic nominees over nominees appointed by Republican presidents, had no choice but conclude that she was well qualified, as a majority of the reviewing board did. Judge Barrett's qualifications are remarkable, and I believe she will serve as an excellent Supreme Court justice. So what is it our Democratic friends have focused on? Well, one thing they've focused on is history. And they claim the fact that this nomination is occurring at all is illegitimate. Doesn't matter who Judge Barrett is, doesn't matter what she's done, doesn't matter her record, doesn't matter her extraordinary family story of doing all of this while being a mom to 7 kids. The timing of the nomination, our Democratic friends tell us, makes it illegitimate. Well, except for that history does not accurately reflect what the Senate has done over 2 centuries. This question of what happens when there's a Supreme Court vacancy during a presidential election year, 2020 is not the first time America has faced that question. Indeed, in our country's history, that question has come up a total of 29 times. So 29 times, presidents have faced the same circumstance. And presidents have nominated individuals to fill those positions all 29 times, 100% of it. Doesn't matter if you're a Democrat or Republican. From a president's perspective, it's easy. If there's a vacancy, even during a presidential election year, you make a nomination. 44 individuals have served as president throughout the history of our country. Half of them, 22 of the presidents we have had, have made Supreme Court nominations for vacancies that occurred during a presidential election year. But what has the Senate done? Well, again, the Senate precedent is quite clear and is something that our Democratic friends do not want to address, do not want to confront. Of those 29 times, 19 of them occurred when the president and the Senate were of the same party. And when the president and the Senate are the same party, history shows that those nominees get confirmed. 17 of those 19 were confirmed for vacancies that occurred during a presidential election year. On the other hand, for those doing math at home, the remaining 10 occurred when the Senate and the president were of different parties. When the president and Senate are of different parties, the Senate over history has confirmed only 2 of those 10 nominees. Again, history is clear. The overwhelming majority of instances that the president and Senate are of different parties, that nominee doesn't get confirmed. That is, of course, what happened with Judge Garland, nominated by President Obama. President Obama was a Democrat, the Senate was in Republican hands, and following tradition of 200 years, the Senate did not confirm that nominee. Now, some might think the difference between whether the Senate and the president are of the same party or different party, that's just a question of partisan alignment, of partisan power. But that actually misunderstands the constitutional structure. The framers of the Constitution deliberately set up a system of checks and balances so that nobody can become a Supreme Court nominee without both the president and the Senate. Each was designed to check the other. That system of checks and balances limits power ultimately and protects the voters. And indeed, the voters made a clear choice. You know, one of the things that is clear from this discussion this morning is Democrats and Republicans have fundamentally different visions of the court, of what the Supreme Court is supposed to do, what its function is. Democratic senators view the court as a super legislature, as a policymaking body, as a body that will decree outcomes to the American people. Now, that vision of the court is something found nowhere in the Constitution. And it's a curious way to want to run a country. Even if on any particular policy issue you might happen to agree with wherever a majority of the court is on any given day, who in their right mind would want the United States of America ruled by 5 unelected lawyers wearing black robes? It's hard to think of a less democratic notion than unelected philosopher kings with life tenure decreeing rules for 330 million Americans. That is not, in fact, the court's job. The court's job is to decide cases according to the law and to leave policymaking to the elected legislatures. Now, look, that doesn't mean policymaking is unimportant. In fact, it means to the contrary, policymaking is very important. And the people need to have a direct check on policymaking. You know what? If a rogue court implements policies you don't like, you, the American people, have very limited ability to check them. If a rogue Congress implements policies you don't like, you have a direct ability to check us by throwing the bums out and voting them out and voting in new representatives. You know, much of the argument this morning has concerned Obamacare. And they've been policy arguments. They're policy arguments that are actually occurring in the Senate, which is the right place for them to occur, a legislative body. But our Democratic colleagues simply want a promise from a judicial nominee that this nominee will work to implement their policy vision of health care. That is not a judge's job. That is not the responsibility of a judge. And in fact, making that promise would be violating the judicial oath. I don't know what will happen in this particular litigation on health care, but I do know that this body should be the one resolving the competing policy questions at issue. Many of our colleagues talked about pre-existing conditions, and I think they have made a political decision. They want this to be the central issue of the confirmation. Well, remember this. Every single member of the Senate agrees that pre-existing conditions can and should be protected. Period. The end. There is complete unanimity on this. Now, it so happens that there are a number of us on the Republican side that also want to see premiums go down. Obamacare has caused premiums to skyrocket. The average family's premiums have risen over $5,000 a year. Millions of Americans can't afford health care because of the policy failures of Obamacare. Those questions should be resolved in this body, in the elected legislature. It's not a justice's job to do that. It's not the court's job to do that. It is the elected legislature's job to do that. Judge Barrett brings impeccable credentials, a judicial temperament, and a faithfulness to the law. That's what we should be looking for in Supreme Court justices. And if Democratic senators want to engage in policy arguments, they can do so here, not by filibustering every bill as they have done, over and over and over again, whether it's pandemic relief or Obamacare relief to lower premiums that expand choices. To date, our Democratic colleagues filibuster everything and then complain nothing gets passed. This is the body that has to resolve those questions. This is also the body that, consistent with 2 centuries of precedent, can, should, and I believe will confirm Judge Barrett as Justice Barrett. Thank you.
Senator Klobuchar.
Welcome, Judge Barrett. This committee is gathered today for what I consider one of its most solemn duties and one that I take very seriously. Federal judges, senators, the President of the United States, we all take an oath to uphold the Constitution. We make promises to do justice, to tell the truth. At its core, that's what judges do, right? Figure out the truth, figure out justice. My mom, a second-grade teacher, spent her life teaching little kids what was right or wrong, what was true or false. I still believe it matters, and so do the American people. But we are dealing with a president who doesn't think truth matters. And he has allies in Congress who in the past defended our democracy, but are now doing his bidding. Senators who clearly set out that the president, a precedent that the president in an election year should wait, that we should have an election, and that then the people choose the president, and the president chooses the nominee. That was your precedent. It has been said that the wheels of justice turn slowly, and justice, on the other hand, can move at lightning speed, as we are seeing here today. We cannot, and you watching at home should not, separate this hearing from the moment we are in and from the judge he is trying to rush through. To respond to Senator Cruz, this isn't a rush to justice. This is a rush to put in a justice whose views are known and who will have a profound impact on your life. And yes, these policies that the court decides, they matter. Where you can go to school, who you can marry, decisions you can make about your own body, and yes, your health care. The president knows this. We have a president who has refused to commit to a peaceful transfer of power after an election. Every candidate does that, but not this guy. We have a president who has fired or replaced 5 inspector generals, Senator Grassley, who has fired an attorney general, an FBI director, and is now going after their replacements. We have a president who divides our country each and every day. He has called our military suckers and losers. He's refused to condemn white supremacists, and he has the gall to hold up a Bible as a prop in front of a church instead of heeding its words, to act justly. And now he says this election will end up in court. Why, Senator Cruz? Does President Trump matter? He is putting the Supreme Court in place, in his words, to, quote, look at the ballots, end quote. Well, I won't concede that this election is headed to the court because you know at home exactly what the president is up to. That's why you're voting. That's why you are voting in droves. Why are you voting? Well, you know that your rights, your health care is on the line. You know that they are trying to push through a justice who has been critical of upholding the Affordable Care Act, and they're doing it in the middle of a pandemic. And you can see here in this room the misplaced priorities of this Republican-run Senate, and it's in your hands to change it. Are they working to pass a bill to help Americans to get the testing they need to save their lives? Are they working to help the moms trying to balance a toddler on their lap while balancing a laptop on their desk? Are they trying to help our seniors isolated, missing graduations and birthdays? Are they passing the bill the House passed that would help our economy? That's not the priority. Instead, they choose to do this. So no, we cannot divorce this nominee and her views from the election we are in. We didn't choose to do this now, to plop a Supreme Court nomination hearing in the middle of an election. They did. So the reason people aren't going to fall for this is because it is so personal. The over 210,000 people who have died, the school canceled, the small business closed, the job you don't have, the degree you couldn't get. It's personal to me because my husband got COVID early on. He ended up in the hospital for a week on oxygen with severe pneumonia. And months after he got it, I find out the president knew it was airborne, but he didn't tell us. We were cleaning off every surface in our house, and my husband got it anyway. We didn't know. And my dad, at 92, he got it in his assisted living. I stood there outside his window in a mask, and he looked so small and confused. He knew who our family was, but he didn't know what was going on. I thought it was going to be the last time that I saw him. He miraculously survived. But Marnie Zhang, she didn't. Marnie was a rising star, the chairwoman of the St. Paul School Board in just 31 years when COVID took her life. Her dad felt sick. She went with him to the hospital because he was scared, and then she got sick, never got off a ventilator, and died. The daughter of Hmong refugees whose parents fled Laos to a refugee camp in Thailand before arriving in Minnesota. Marnie and her 7 siblings grew up in St. Paul. Their family, the American dream. This is who this virus has taken from us. Someone who has left behind a mother and a father and 7 siblings who loved her, and someone who undoubtedly would have made the world a better place. The president could have saved so many lives. Instead, he's been reckless, packing people in without masks for your nomination party, Judge Barrett. 35 people got sick. The president himself ends up in the hospital, and when he leaves Walter Reed still contagious, he defiantly takes off his mask and walks into the White House. And then he lies and says the virus will magically go away. The truth matters. And the truth is, America, that this judicial nominee has made her views so clear, and this president is trying to put her in a position of power to make decisions about your lives. The Affordable Care Act protects you from getting kicked off of your insurance. That's on the line. The president has been trying to get rid of Obamacare since he got in power. John McCain went in and stopped it with that big thumbs down. Then they went and brought a case to the U.S. Supreme Court, and they're now trying to stack the deck against you right now. The last time this was before the court in a big way was when Justice Roberts, not exactly a blazing liberal, voted the same as Justice Ginsburg to uphold the Affordable Care Act. And this nominee, she criticized him. America, this is about you. It's about these 2 girls up here, Evelyn and Mariah, identical twins from Cambridge, Minnesota, honor roll students, star athletes. They play in the softball team. One's a pitcher, one's a catcher. They also play basketball. One of them got severe diabetes when she was very young. Doesn't matter which one, the pitcher, the catcher, they both deserve good health care. They get that with one stroke of a pen, one judge can decide if millions of Americans, including their family, would lose their insurance. One judge can decide if millions of Americans can lose their right to keep their kids on their insurance till they're 26 years old. One judge can decide that if seniors' prescription drugs, which already are too high, could soar even higher. This is a judgeship that was held by an icon who voted to protect your health care, Ruth Bader Ginsburg, a woman who never took no for an answer. When they told her a girl shouldn't go to law school, she graduated first in her class. And when they told her a man should argue landmark equal protection cases because maybe they'd have a better chance of winning, she did it herself, and she won. She never gave up. She had her own hashtag well into her 80s, the notorious RBG. And her last fervent wish was that a new president, the winner of this election, would pick her replacement. When you look at her opinions, you realize she wasn't just writing for today, she was writing for tomorrow. To the women of America, we have come so far, and in the name of RBG, we should not go backwards. As the rabbi said at Justice Ginsburg's memorial in the Capitol, her dissents, her strong words when she would disagree with the Republican-appointed justices, her words were never cries of defeat. They were blueprints for the future. So to all Americans, this hearing, whatever these guys try to do, whatever you hear from me, it will not be a cry of defeat. It will instead be our blueprint for the future. Yes, Judge, I think this hearing is a sham. I think it shows real messed up priorities from the Republican Party. But I am here to do my job, to tell the truth. To all Americans, we don't have some clever procedural way to stop this sham, to stop them from rushing through a nominee, but we have a secret weapon that they don't have. We have Americans who are watching, who work hard every day, believe in our country and the rule of law, whether they are Democrats, Republicans, or independent. They know what this president and the Republican Party are doing right now is very wrong. In fact, 74% of Americans think we should be working on a COVID relief package right now instead of this. Let me tell you a political secret. I doubt that it will be a brilliant cross-examination that's going to change this judge's trajectory this week. No, it is you. It is you calling Republican senators and telling them enough is enough, telling them it is personal, telling them they have their priorities wrong. So do it. And it is you voting even when they try to do everything to stop you. It is you making your own blueprint for the future instead of crying defeat. So do it. This isn't Donald Trump's country. It is yours. This shouldn't be Donald Trump's judge. It should be yours. Thank you, Mr. Chairman.
Senator Sass.
Thank you, Mr. Chairman. Judge Barrett, welcome. Congratulations. Jesse Barrett, congratulations. I just want to say, Senator Klobuchar said a number of things about COVID that I agree with. She cited a bunch of really painful stories in Minnesota, and similar stories could be told from across the country. I even agree with parts of her criticism of the mismanagement of COVID by Washington, D.C. I don't know what any of that has to do with what we're here to do today. Huge parts of what we're doing in this hearing would be really confusing to eighth graders. If civics classes across the country tuned into this hearing and tried to figure out what we're here to do, and they heard as much as they've heard about 2009 Finance Committee debates about what should be in a healthcare reform package. I'm blessed to sit not just on the Judiciary Committee, but also on the Finance Committee, and lots of the discussions we've had in here today fit better in a Finance Committee hearing than in a Judiciary Committee hearing. So I think it would be very useful for us to pause and remind ourselves and do some of our civic duty to eighth graders to help them realize what a president runs for, what a senator runs for, and on the other hand, why Judge Barrett is sitting before us today and what the job is that you're being evaluated for. So if we can back up and do a little bit of eighth grade civics, I think it would benefit us and benefit the watching country, and especially watching eighth grade civics classes. So I'd like to distinguish first between civics and politics, because there was a time, the chairman said at the beginning of this hearing, there was a time when people that would be as different as Ruth Bader Ginsburg, and she was a heroic woman, that's absolutely true, and Antonin Scalia, another brilliant mind and your mentor, people that different could both go through the Senate and get confirmation votes of 95 or 98 votes. And the chairman said at the beginning of the hearing, he doesn't know what happened between then and now. I think some of what happened between then and now is we decided to forget what civics are and allow politics to swallow everything. So if I can start, I'd like to just remind us of the distinction between civics and politics. Civics is the stuff we're all supposed to agree on, regardless of our policy views differences. Civics is another way we talk about the rules of the road. Civics 101 is the stuff like Congress writes laws, the executive branch enforces laws, courts apply them. None of that stuff should be different if you're a Republican or a Democrat or a Libertarian or a Green Party member. This is basic civics. Civics is the stuff that all Americans should agree on, like religious liberty is essential. People should be able to fire the folks who write the laws, and the voters can't fire the judges. Judges should be impartial. This is just Civics 101. Politics is different. Politics is the stuff that happens underneath civics. Civics is the overarching stuff we as Americans agree in common. Politics is the subordinate, less important stuff that we differ about. Politics is like if I look at my friend Chris Coons and I say, listen up, jackwagon, what you want to do on this particular finance committee bill is going to be way too expensive and might bankrupt our kids. Or if Chris looks back at me and says, listen up, jackwagon, you're too much of a cheapskate and you're underinvesting in the next generation. That's a really important debate. That's a political debate. That's not civics. Civics is more important than that. Civics doesn't change every 18 to 24 months because the electoral winds change and because polling changes. I think it's important that we help our kids understand that politics is the legitimate stuff we fight about, and civics is the places where we pull back and say, wait a minute, we have things that are in common, and before we fight again about politics, let's reaffirm some of our civics. So I'd like to have just sort of a basic grammar of civics for 5 minutes, one thing that we should all agree on, and two things that we should all disagree with. We should agree on it, but one thing that we agree about and are in favor of, and two things that we agree on that we should all reject. First, a positive, grand, unifying truth about America, and that is religious liberty. Religious liberty is the basic idea that how you worship is none of the government's business. Government can wage wars, government can write parking tickets, but government cannot save souls. Government's really important. War is important. Parking tickets are important. But your soul is something that the government can't touch. So whether you worship in a mosque or a synagogue or a church, your faith or your lack of faith is none of the government's business. It's your business and your families and your neighbors and all sorts of places where people break bread together and argue. But it's not about power. It's not about force. It's not about the government. This is the fundamental American belief. Religious liberty is one of those 5 great freedoms clustered in the First Amendment. Religion, speech, press, assembly, and protest. These 5 freedoms that hang together, that are the basic pre-governmental rights, are sort of Civics 101 that we all agree on well before we ever get to anything as relatively inconsequential as tax policy. So civics should be the stuff we affirm together. And contrary to the belief of some activists, religious liberty is not an exception. You don't need the government's permission to have religious liberty. Religious liberty is the default assumption of our entire system. And because religious liberty is the fundamental 101 rule in American life, we don't have religious tests. This committee isn't in the business of deciding whether the dogma lives too loudly within someone. This committee isn't in the business of deciding which religious beliefs are good and which religious beliefs are bad and which religious beliefs are weird. And I just want to say, as somebody who's self-consciously a Christian, we got a whole bunch more really weird beliefs. Forgiveness of sins, the virgin birth, resurrection from the dead, eternal life. There are a whole bunch of really, really crazy ideas that are a lot weirder than some Catholic moms giving each other advice about parenting. And yet there are places where this committee has acted like it's the job of the committee to delve into people's religious communities. That's nuts. That's a violation of our basic civics. That's a violation of what all of us believe together. This is not a Republican idea. It is not a Democrat idea. It's a Democrat idea and a Republican idea, but more fundamentally, it's an American idea. And the good news is, whether you think your religious beliefs might be judged wacky by someone else, it's none of the business of this committee to delve into any of that in this context. Because in this committee and in this Congress and in this constitutional structure, religious liberty is the basic truth. And whatever you or I or Judge Barrett believe about God isn't any of the government's business. We can all believe in that in common. We should all reaffirm that in common. And that should be on display over the course of the next 4 days in this committee. Now, a couple of terms that all of our 8th graders should know as things we should reject in common. And again, shared rejection, not Republican versus Democrat or Democrat versus Republican, but a shared American rejection. And the first is this: judicial activism. Judicial activism is the idea that judges get to advocate for or advance policies even though they don't have to stand for election before the voters and even though they have lifetime tenure. Judicial activism is the really bad idea that tries to convince the American people to view the judiciary as a block of progressive votes and conservative votes, Republican justices and Democratic justices. This is the confused idea that the Supreme Court is just another arena for politics. When politicians try to demand that judicial nominees, who are supposed to be fair and impartial, when politicians try to get judicial nominees to give their views on cases or to give their views on policies, to try to get them to pre-commit to certain outcomes in future court cases, we are politicizing the courts, and that is wrong. That is a violation of our oath to the Constitution. Likewise, when politicians refuse to give answers to the pretty basic question of whether or not they want to try to change the number of justices in the court, which is what court packing actually is, when they want to try to change the outcome of what courts do in the future by trying to change the size and composition of the court, that is a bad idea that politicizes the judiciary and reduces public trust. On the other hand, depoliticizing the court looks a lot like letting courts and judges do their jobs and the Congress do our jobs. You don't like the policies in America? Great, elect different people in the House and in the Senate and in the presidency. Fire the politicians at the next election. But voters don't have the freedom to fire the judges. Therefore, we should not view judges and we should not encourage judges or the public to view them as ultimately politicians who hide behind their robes. The antidote to judicial activism is originalism. Originalism, also known as textualism, is basically the old idea from 8th grade civics that judges don't get to make laws. Judges just apply them. An originalist comes to the court with a fundamental humility and modesty about what the job is that they're there to do. An originalist doesn't think of herself as a super legislator whose opinions will be read by angels from stone tablets in heaven. Judicial activism, on the other hand, is the bad idea that judges' black robes are just fake, and truthfully, they're wearing red or blue partisan jerseys under there. We should reject all such judges. And so today, when we have a nominee before us, we should be asking her questions that are not about trying to predetermine how certain cases will be judged. And a final term that we should be clear about, I mentioned earlier, but I think it's worth underscoring, is we should underscore what is court packing. Court packing is the idea that we should blow up our shared civics, that we should end the deliberative structure of the Senate by making it just another majoritarian body for the purposes of packing the Supreme Court. Court packing would depend on the destruction of the full debate here in the Senate, and it is a partisan suicide bombing that would end the deliberative structure of the United States Senate and make this job less interesting for all 100 of us. Not for 47 or 53, because it's hard to get to a supermajority that tries to protect the American people from 51, 49, 49, 51 swings all the time. What blowing up the filibuster would ultimately do is try to turn the Supreme Court into the ultimate super legislature. Court packing is not judicial reform, as some of you who wrote the memo over the weekend got a lot of media to bite on. Court packing is destroying the system we have now. It is not reforming the system we have now. And anybody who uses that the language that implies filling legitimate vacancies is actually just another form of court packing that's playing the American people for fools. And the American people actually want a Washington, D.C. that depoliticizes more decisions, not politicizes more decisions. So, Judge, I'm glad that you're before us. I'm looking forward to hearing your opening statement later today, and I look forward to the questioning you have to endure over the next 2 or 3 days, even though you probably look forward to it a little bit less. Congratulations and welcome.
Senator Coons.
Thank you, Mr. Chairman. Judge Barrett, to you and your family, welcome. Over the past weeks, I've been flooded with calls, texts, emails from Delawareans. Delawareans who are scared because they are worried about their own health, the health of a parent or child, because they don't know if it's safe for their kids to go to school, if their businesses will survive, or because they're wondering why on earth this Senate is focused on racing forward with a Supreme Court nominee, but is not willing to take a vote to provide needed relief for them and their families. It is an understandable question when we're in the midst of a devastating global pandemic in which more than 210,000 Americans have died, more than 7 million have been infected and have a new pre-existing condition, why there were just 300,000 new cases this week. And today, more than 25 million Americans are collecting unemployment. This is an ongoing national emergency, and as an exercise in civics, not politics, we in Congress should be working day and night to deliver them that relief. Instead, my colleagues are barreling forward with a confirmation hearing that's distracting from our responsibility to our constituents and threatens to further tear our nation apart. Mr. Chairman, as you know, we're just 22 days from an election. There is no precedent, despite my colleagues' lengthy and I think hypocritical lecture about the history. There is no precedent in our nation's history for confirming a Supreme Court nominee by the Senate this close to a presidential election, in which a majority of states are already voting. In fact, 6 million Americans have voted. This process flies in the face of the very rule Republicans set themselves in 2016, when they refused, as a matter of politics, not of civics, to even consider a highly qualified nominee, Judge Merrick Garland, 9 months before an election, simply because it was an election year. And Mr. Chairman, in 2018, you went a step further and said, if an opening on the Supreme Court came up in the last year of President Trump's term, you would wait until the next election and let the voters decide. So what changed? Sadly, nothing. Nothing except the fact that this time, President Trump and his allies in the Senate saw a chance in Justice Ginsburg's untimely passing to shift the balance of the Supreme Court for decades to come, and that will have consequences in the real lives of millions of Americans. Proceeding with this confirmation today is wrong. And if I could, to my colleague who just spoke, religious liberty, I agree, is foundational to our civics and our republic. And I and my colleagues will focus, Judge Barrett, on your legal writings, your opinions, your articles, your speeches as a law professor and judge. And I think when we do that, we will conclude the ways in which you may serve as a justice will do irreparable harm. I think proceeding with this nomination in this way at this time will also do harm to what remaining trust we have in each other, to the Senate as a whole, and potentially to the court itself. As if all of this weren't reason enough for us to delay, we're proceeding despite having 2 members of this committee who've contracted the virus. That's why the Senate's out of session today. That's why all of us, when not speaking, are wearing masks. That's why the distance between us. In light of all of this, in light of the stresses on our country, I think this rushed, hypocritical, partisan process should not proceed. But instead we are. So let me try and help explain to those who've reached out to me why and why it matters. Centrally, it's this. President Trump has promised over and over and over again that he would repeal the Affordable Care Act. He ran on that promise, but despite his very best efforts, he's failed. My Republican colleagues here and in the House have voted over and over and over to repeal the Affordable Care Act since it was passed a decade ago. But thankfully for the people of our nation and my state, they too have been unsuccessful. And yet today, to make good on this promise to achieve what they could not accomplish through the democratic process, they're looking to the courts, in fact, to the court. They're looking to this nominee. President Trump explicitly promised anyone he nominated to the Supreme Court would do the right thing and be a vote to overturn the Affordable Care Act. And just 1 week after the upcoming election, the Supreme Court will hear a case in which the Affordable Care Act is at issue and where the Supreme Court will hear argument that supports the Trump administration and the Trump's Department of Justice position to strike down this landmark law. So let me be clear. Just a week after the upcoming election, the Trump administration will be telling the Supreme Court to tear down the very law that provides health care protections in the middle of an ongoing pandemic. Judge Barrett, you've publicly criticized the Supreme Court's past decisions upholding the Affordable Care Act, and I think that is appropriately at issue in the days to come. The President knows this, and it's one reason why he and my colleagues are rushing to have this confirmation just in time to hear the administration's challenge to the Affordable Care Act. I don't think this is a coincidence. It's beyond ironic that this administration, which has failed to respond to this pandemic, is rushing through a judge they believe will vote to strip away health care protections. Today, because of the Affordable Care Act, insurance companies cannot discriminate against women for being women. They cannot charge more. They cannot treat pregnancy as a pre-existing condition. I cannot think of a sharper irony as we consider the legacy of Justice Ginsburg, who dedicated her life to fighting for gender equality. It also prevents insurance companies from charging any with pre-existing conditions more, so Americans no longer have to worry about going bankrupt because of an unexpected illness or accident. Don't take my word for it. Listen to the voice of Carrie, who's behind me to my right. Carrie from Middletown, Delaware, used to pay $800 a month for junk insurance, as she called it, coverage so skimpy She had to live in fear of going to the doctor's office or needing medication. Because of the ACA, she was able to get better coverage to pay what she can afford based on her income. She has diabetes, she has high blood pressure, but thanks to the ACA, she can't be denied care or coverage. She told me when he spoke, this takes the stress and the worry out of it, and then asked me, how is this even at issue? Wasn't that settled years ago? Carrie's right. She should have the peace of mind that you can care for yourself and your family if you get sick. I've heard so many more stories from Delaware. Just over my shoulder here is Debbie from Newcastle, a self-employed small business owner who receives her health insurance through the marketplace. Her pre-existing condition requires her to attend physical therapy and doctor's appointments multiple times each month. Without the ACA, insurance companies would have charged her more because of her condition, and she wouldn't be able to afford her medical bills and support her small business. There's Barb Slater from Newark, Delaware, who was diagnosed with scleroderma 4 years ago. After losing her employer-sponsored health insurance, she was able to find new coverage in the marketplace thanks to the Affordable Care Act. My inbox and the inbox of all my colleagues are filled with stories like Carrie's, Debbie's, Barb's, and they highlight the breadth of what the ACA means to the American people. The ability of young people to stay on their family's insurance, lower out-of-pocket costs for seniors' prescriptions, the elimination of lifetime caps. These protections are on the line in the ballot and on the docket of the Supreme Court. And it's not just the ACA at risk. Judge, I'm deeply concerned about ways in which your approach to something that may sound abstract to folks watching stare decisis or precedent, that means your approach to reviewing and reconsidering and possibly overturning long-settled cases may overturn some of the very principles for which Justice Ginsburg fought her entire adult life, principles that protect settled fundamental rights for all Americans. What might this mean? Cases like Griswold versus Connecticut that establish married couples have a right to obtain and use contraception in the privacy of their own home may be in danger of being struck down. It means cases like Roe versus Wade, which protects a woman's right to make her own critical health care decisions, may be on the line. And it means Obergefell versus Hodges, which made marriage equality the law of this land, could be overruled just a day after we celebrated Coming Out Day nationally, stripping LGBTQ individuals of what Justice Kennedy memorably called equal dignity in the eyes of the law. This is what I believe is at stake with this nomination. Judge Barrett, you will be deciding cases that have real daily impacts on the lives of millions of Americans. They deserve to understand why President Trump nominated you and what consequences your decisions may have on them and their lives. I've heard my Republican colleagues say all they care about is finding a future justice who will apply the law as written, as if all this is about today is an abstract fight about interpretive methodology and jurisprudence. They seem shocked we're talking about what the Supreme Court might do if Judge Barrett were to become Justice Barrett. But Judge Barrett, I'm not suggesting you made some secret deal with President Trump, but I believe the reason you were chosen is precisely because your judicial philosophy, as repeatedly stated, could lead to the outcomes President Trump has sought. And I think that has dramatic and potentially very harmful consequences with regards to the election, the Affordable Care Act, and long-settled rights. This is what I intend to lay out this week, and this is what I hope the American people will hear in the course of this confirmation hearing. Thank you, Mr. Chairman.
Thank you, Senator Coons. For planning purposes, I think I talked to Senator Feinstein. We will go to Senator Hawley, Blumenthal, and Tillis. We'll take a 30-minute break to grab a bite to eat and take a little bit of a break and come back and finish up. So, Senator Hawley.
Thank you, Mr. Chairman. Judge Barrett, welcome. It's good to see you again. Jesse Barrett, welcome, and to you and to your family as well. I see that some of your children are getting a break. They've earned it, I think. I'm amazed as I've been watching. I've got 2 little boys at home, my wife and I do. I can't believe how calmly your children have been sitting for a couple of hours. So maybe you can give me some tips, Jesse and Judge, when we're finished here. You know, we've gotten to read a lot about your family in the last few weeks. We've gotten to read a lot about you in the press, and in particular about your religious beliefs. One attack after another. in the liberal media, one hit piece after another, many of them echoed by members of this committee, like this one, for instance, Barrett, long active with Insular Christian Group. We've read stories about your Catholic lifestyle, stories about how you raise your children, stories about how you adopted your children, stories about your Catholic doctrinal beliefs, over and over and over questioning whether you have, I guess, the independence to be a judge, a justice on the United States Supreme Court. And it's not just in the newspapers, it's members of this committee, including the Democratic nominee for Vice President of the United States, who has questioned past nominees who have come before this committee about their membership in Catholic fraternal organizations like the Knights of Columbus. And for those watching at home, that's right, you heard me correctly. Senator Harris and others on this committee have repeatedly questioned judicial nominees' fitness for office because of their membership in the Knights of Columbus. The ranking member, when you were last before this committee, Judge, for your initial confirmation hearings, the ranking member referred to your Catholic convictions as dogma, that's a quote, that lives loudly within you, picking up the very terminology of anti-Catholic bigotry current in this country a century ago. She wasn't alone. Other senators on this committee last time asked you if you were an Orthodox Catholic. One senator said she worried that you would be a Catholic judge if you were confirmed because of your religious beliefs, I guess as opposed to an American judge, as if you can't be both a devout Catholic and a loyal American citizen. And it's not just you, Judge. Other nominees who have come before this committee for years now have been asked by my Democrat colleagues over and over their views on sin, their views on the afterlife, their views about their membership statements of Catholic organizations, about their membership in other Christian organizations, and on and on and on. And let's be clear about what this is. This is an attempt to broach a new frontier, to set up a new standard. Actually, it's an attempt to bring back an old standard that the Constitution of the United States explicitly forbids. I'm talking about a religious test for office. Article 6 of the Constitution of the United States, before we even get to the Bill of Rights, Article 6 of the Constitution of the United States says clearly, and I quote, "No religious test shall ever be required as a qualification to any office or public trust under the United States." Now, that was big news in 1787 when it was written, and it's worth remembering why. It's because no country, no republic in the history of the world had ever guaranteed to its citizens the right to freedom of conscience and religious liberty. Every other country that had ever existed tied together the religious beliefs that would be approved by the powerful and the right to serve in office, or to vote, or just to be a citizen. In every other country across history, you had to agree with what those in power agreed with in order to hold office or be a citizen in good standing. You had to sign a particular religious confession, or you had to disavow a particular religious group, swear not to follow the Pope, for instance. You had to pledge allegiance to the God of the city or the God of the empire. This was true from 18th century Britain all the way back to ancient Rome. And so when our founders put Article 6 into the Constitution of the United States, they were making a very deliberate choice. They were breaking with all of that past history, and they were saying in America it would be different. In the United States of America, we would not allow the ruling class to have veto power over your faith, over what Americans believed, over who we gathered with to worship and why and where and how. No, in this country, the people of the United States would be free to follow their own religious convictions, free to worship, free to exercise their religion, and people of faith would be welcome in the public sphere. They'd be welcome there. They'd be welcome without having to get the approval of those in power, like those on this committee. They would be welcome to come and to bring their religious beliefs to bear on their lives, on their office, and all that they do, so long, of course, as they were peaceful citizens who followed the law. Religious people of all backgrounds would be welcome in public life, and no person in power would be able to control what the American people, any American citizen, thought or believed or who they worshiped. This freedom of conscience and religious liberty undergirds all of our other rights. because it tells the government that it cannot tell us what to think or who we can assemble with or how we can worship or what we can say. And that's why Article 6 is there even before we get to the Bill of Rights and the First Amendment. But this bedrock principle of American liberty is now under attack. That is what is at stake when we read these stories attacking Judge Barrett for her faith. That is what is at stake when my Democratic colleagues repeatedly question Judge Barrett and many other judicial nominees about their religious beliefs, about their religious membership, about their religious practices, about their family beliefs and practices. That is an attempt to bring back the days of the religious test. That is an attempt to bring back the veto power of the powerful over the religious beliefs and sincerely held convictions of the American people. And that is what is at stake in this confirmation hearing. Judge Barrett is a Catholic. We all know that. She's a devout Catholic. We all know that. She and her husband have chosen to raise their family according to their Catholic beliefs in faithful fellowship with other Catholics. We all know that. Heck, 65 million Americans are Catholics, and many millions more are Christians of other persuasions. Are they to be told that they cannot serve in public office, that they are not welcome in the public sphere unless the members of this committee sign off on their religious beliefs? I, for one, do not want to live in such an America, and the Constitution of the United States flatly prohibits it. Now, the Constitution says that people of faith, like Judge Barrett, are welcome in high office, welcome in any office, welcome throughout our public life here in this country. And I would just say to my Democrat colleagues that these years now, this pattern and practice, as we say in the law, this pattern and practice of religious bigotry, because that's what it is. When you tell somebody that they're too Catholic to be on the bench, when you tell them they're going to be a Catholic judge, not an American judge, that's bigotry. The pattern and practice of bigotry from members of this committee must stop. And I would expect that it be renounced. Now, I just heard my colleague, Senator Coons, make a reference to an old case, the Griswold case, which I can only assume is another hit at Judge Barrett's religious faith, referring to Catholic doctrinal beliefs. I don't know what else it could be, since no one has challenged this case. It is not a live issue and hasn't been for decades. This is the kind of thing I'm talking about, and this is the sort of attacks that must stop. I look forward, Judge Barrett, to getting to the chance to speak with you further about your legal credentials, about your legal views, about your approach to the law and your judicial philosophy. But I hope that one thing that this confirmation process will stand for in the end, I hope when we look back at the confirmation hearings for Judge Amy Barrett, soon I hope to be Justice Amy Barrett, one thing we will say is that was the time, that was the year that the attempt to bring back religious tests for office was finally stopped. Thank you, Mr. Chairman.
Senator Blumenthal.
Thank you, Mr. Chairman. Judge Barrett, and to your family, welcome to the committee. I want to introduce you to one of my constituents, Connor Kern of Ridgefield, Connecticut. He is 10 years old, and he suffers from Duchenne muscular dystrophy. It is a horrible, incurable disease. It slowly deprives children of the strength and their ability to move. Eventually, it robs them of their lives. The costs of providing Connor's care are astronomical, but for Connor and his family, it is worth every penny. Connor is a superhero, but he's always had a real sidekick. He's had the protection of the Affordable Care Act. It has shielded him and his family from arbitrary caps on coverage that would have cut off his care when it became too expensive. It has protected Connor from losing insurance because of this insidious disease that he never caused and chose. The Affordable Care Act has given his family a measure of relief, of hope, of peace. They still worry about Connor's health, but not their coverage or its costs. Connor and millions of others like him are why I will oppose your nomination. Your nomination is about the Republican goal of repealing the Affordable Care Act, the Obamacare they seem to detest so much. It's about people like Connor, protections for people with pre-existing conditions, tax credits that make health insurance more affordable, bans on charging women more simply because they are women. That's what my Republican colleagues have been fighting to repeal for the last decade. They voted dozens and dozens of times to repeal the Affordable Care Act, and they have challenged it twice unsuccessfully in the United States Supreme Court. And each time they failed, but now, just 1 week after the election, as you know, the fate of the Affordable Care Act will be again in the hands of the United States Supreme Court. Republicans have turned again to the court to try to achieve judicially what they cannot achieve legislatively. President Trump has vowed that any judge he nominated would pass the very strong test, his words, and that they would strike down the Affordable Care Act. Judge Barrett, in all honesty, you have auditioned for this job through your academic writing and judicial opinions, and you've passed that test. In fact, you've stated twice in effect that you would have voted to strike down the Affordable Care Act had you been a justice at the time. You've been vetted, you've been screened by the Trump administration and special interests who want an activist judge. They want someone who will legislate from the bench and strike down laws supported by a vast majority of the American people. And that activism uses originalism as a smokescreen. If the American people have any doubts about how dedicated my Republican colleagues are to taking away people's health care, just listen to their own words. They've been remarkably candid and forthright. Senator Graham, our chairman, has said, "You can't repair this monstrosity," I'm quoting, "you can't repair this monstrosity called Obamacare. You have to tear it down and start over." Senator Ernst has said, quote, "I support immediate action to repeal Obamacare and replace it." Senator Cornyn, "It's time to repeal and replace." Senator Tillis, "Repeal Obamacare. Let's end this disaster." And President Trump himself has said, "We want to terminate Obamacare." Millions of Americans, more than 130 million, have a pre-existing condition: asthma, heart disease, diabetes, cancer, Parkinson's, pregnancy, and now, by the cruelest of ironies, COVID-19. COVID-19, the cause of this pandemic, now is a pre-existing condition that could prevent millions of Americans from being covered by health care. Stripping health care from millions of Americans during a pandemic, that's really what is at stake in the Republican lawsuit, now before the Supreme Court, and in this nomination. And sadly, it's not just the Affordable Care Act that's at stake. It's a woman's right to decide when and how to have a family, control over her own body. An activist judge on the bench doing what Congress could not do would also strike down common sense gun safety laws. Connecticut has been at the forefront on gun violence protection. On gun safety, Judge, you acknowledged that your dissenting opinion in Canner sounds kind of radical, that's because it is. But if your views on the Second Amendment are adopted by the Supreme Court, it would imperil common sense state laws like Connecticut's all around the country. Today, we ought to be working on improving American health care. We ought to be fighting COVID-19, which has infected 8 million Americans and killed more than 215,000. We should be producing a national testing strategy, instituting effective contact tracing, and securing sufficient PPE. We ought to be providing assistance to the millions of Americans who have lost their job and face economic hardship and heartbreak. President Trump has failed to do any of it. Instead, he and our Republican colleagues are riveted on rushing a judge through this sham process, dropping everything else. President Trump's failure to act will likely lead to 55,000 additional deaths, 55,000 additional Americans lost over just the next 3 months. Senate Republicans are refusing to address American health care or COVID-19 or economic relief because they care more about putting an extremist ideological judge on the bench and not just on the Supreme Court. I've learned as a senator that there are very few unwritten rules, very few written rules, I should say, in this place. But there is one very important unwritten rule. Keep your word. Republicans have all sorts of excuses for why they are breaking their promise, the promise that they would not confirm a Supreme Court justice during an election year. Each excuse boils down to nothing more than raw political power. They're doing it because they can. But might does not make right. They have boasted they have the votes, but they don't have the American people and they don't have history on their side. The American people want a plan to fight and conquer this disease. They want a plan to put Americans back to work. They want a blueprint for the future, not rolling back rights and turning back the clock. I revere the Supreme Court. I clerked for Justice Harry Blackmun. I've argued cases before the court 4 times. Now I'm really deeply concerned that the Supreme Court is losing the trust and respect of the American people. The authority of the Supreme Court depends on that trust. It has no army or police force to enforce its decisions. The American people follow the Supreme Court's commands, even when they disagree, because they respect its authority. And now, President Trump and the Republican Senate are eroding, indeed destroying, that legitimacy. They've stripped the American people of their say in this process simply to confirm a justice who will strike down in court, legislate from the bench, what they can't repeal in Congress. Your participation, let me be very blunt, in any case involving Donald Trump's election would immediately do explosive, enduring harm to the court's legitimacy and to your own credibility. You must recuse yourself. The American people are afraid and they're angry, and for good reason. It's a break the glass moment. Americans must use their voices to speak out and stand up, to contact my colleagues on this committee, despite their boasts about having the votes. Stand up and speak out to protect their own health, public health, and the health of our democracy. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. We will now have Senator Tillis, who's with us remotely. After his opening statement. We will come back at 12:20. And Senator Hirono, you will be the first one to make a statement. So, Senator Tillis.
Thank you, Chairman Graham and Ranking Member Feinstein. I want to take a moment to honor the life and legacy of Justice Ginsburg. She was a living legend and a giant in the legal world as a professor, as a lawyer, and as a judge and a justice. She was an inspirational model and role model, and we honor her legacy. And I just want to make sure that her family knows the nation mourns her loss. But today we're here to consider a nomination of a highly qualified jurist to the United States Supreme Court, Judge Amy Coney Barrett. She's a top legal scholar, a professor in the mold of the late Justice Scalia. Her work is widely respected in the legal community, and it's clear why her former students voted her multiple times to be the Distinguished Professor of the Year at the Notre Dame Law School. It's also why every full-time faculty member of Notre Dame Law supports her nomination. Her legal work and teaching have inspired hundreds of young lawyers, especially aspiring female lawyers. She's a remarkable mother. She has 7 beautiful children, and in spite of being busy working as a Seventh Circuit Justice, she makes time to be involved in her community. And this nomination is important because it's going to have a lasting impact on our republic. A justice service on the bench involves every important issue facing our constitutional republic. What are the limits of abusive and intrusive government power? What's the proper role of each branch of government? And what are the fundamental protections that our Constitution grants all Americans? These are foundational questions for the Supreme Court, and they consider them every single term. If confirmed, Judge Barrett will be tasked with answering these questions, and I believe she's going to do a great job. But it's not the rights enshrined in the Constitution that's most important. It's the structure of the document itself that ensures our freedom. Justice Scalia understood this. He was fond of saying, every dictator in the world, every president for life has a Bill of Rights. That's not what makes us free. What makes us free is our Constitution. Think of the word Constitution. It means structure. Justice Scalia went on to note the genius of our founding generation is that it dispersed power across multiple departments. The real danger to our constitutional republic is centralization of power in any one part of government. When that happens, liberty dies and tyranny reigns. That's why it's critical that Supreme Court justices maintain the proper role. They decide cases. They don't make policy. In recent decades, the court has drifted towards a trend where it decides majority disputes over policy rather than reserving those decisions for the American people through acting through their elected representatives, people like those of us in the U.S. Senate. Article III judges cannot and should not be policymakers. We've heard many speak today about policy priorities that they'd like an act of this court to pass. Several of my colleagues have engaged in fear-mongering and described Judge Barrett's nomination as an end to health care, abortion rights, labor rights, and the list goes on and on and on. These statements are unfair and they're untrue. This week, they'll attempt to have Judge Barrett commit to policy outcomes rather than do the work for that policy outcome in the U.S. Senate. Just last month, while they were falsely claiming Judge Barrett's nomination would bring an end to the protections for pre-existing conditions, every single Democrat on this committee voted against a measure that would do just that. They're failing to do their job, and they want the court to do it for them. My review of Judge Barrett's record convinces me she's not only one of the most qualified individuals ever to be nominated, but she also understands the proper role of the Article III branch. She reaches conclusions dictated by the law, not by personal preference. That's the right thing to do. My Democratic friends decry the idea a nominee has predetermined outcome in mind, while in the same breath, they demand the nominee agree to their preferred outcome of a case. The hypocrisy is incredible. They ignore a central fact. Judge Barrett's rulings aren't meant to be for or against a particular policy outcome. She's not a legislator. That's our job. However, when the minority can't get their bad policies passed in Congress, they turn to the courts to demand that judges interpret the law not as written, but as they prefer. Her opinions simply order the outcome the law dictates. As passed by Congress, a politically accountable branch, nothing more and nothing less. My Democratic colleagues claim they care about the First Amendment, the Fifth Amendment, the 14th Amendment. If they care about our constitutional liberties, then they should care about confirming a judge who understands the proper role of the Supreme Court. Rights granted by none can just as easily be ended by none. To quote Justice Ginsburg, real change, enduring change, happens one step at a time. It doesn't happen by judicial fiat. Judge Barrett understands that principle. She knows the role of the Supreme Court Justice, and she is highly qualified to do this job. Judge Barrett, when I met with you in the Capitol, I asked you to sign 2 pocket constitutions for my 2 granddaughters, and in it you wrote, "Dream big." When they're old enough to understand the significance, I'm going to explain to them that just like Justice Barrett, they can, with hard work and determination, realize their American dream. So for the next few days, when members of this committee mischaracterize your views, their allies in the liberal media are saying terrible things about you and your family, stand tall, stand proud, and stand true. Rely on your faith. I know that you're an inspiration to millions of young women in this country, like my granddaughters, and we're proud of you. Thank you, Judge Barrett, for being with us today. Congratulations on the recognition of your hard work and your character. I look forward to hearing your testimony. Thank you, Mr. Chairman.
Thank you, Senator Tillis. We'll be in recess until 12:20. We'll start back with Senator Hirono.